Hello all, welcome back. Hope you are doing fine. Previous video, I covered a few topics. Those who are not watched those topics, please go and watch. I am giving them on the description. Today we are going to cover a few more topics. Let's start the video. Conversion of a public company into private company or conversion of a private company into public company. That is what do mean vice versa. Okay, first one, A. Conversion of a public company into a private company. So, how a public company can be converted into a private company? So, this is they are going to explain. A public company can be converted into a private company by passing a special resolution after altering its articles so as to include therein the restrictions contained in Section 2, Clause 68 of the Act. A public company can be converted into a private company by passing a special resolution. Why the special resolution need to be passed? After altering it articles of association. So every company in its incorporation time, there will be some articles of association and memorandum of association. In the articles of association, it will be clearly described like what are the duties and responsibilities of a public company. But in the middle of after gaining some years of experience, they will decide. So it will be better for us to do the business by converting into a private company. Then they have to change the articles of association also. So for this they have to pass a special resolution by altering the articles of association. A special resolution passed to convert a public company into a private company is binding on dissenting shareholders provided it is a bona fide, so is the interest of the company as a whole and is consistent with the objects in memorandum of association. So, while converting a public company into a private company, so a special resolution should be passed. In the special resolution, it should be mentioned that this conversion is taking place with the interest of all shareholders, stakeholders, and what are the duties that we are established at the formation of company are going to be carried forward even in its conversion to a private company. Like that, all the things are should be mentioned in that special resolution. Next. Under Section 14 Clause 1, any alteration made in the articles to convert a public company into a private company shall take effect only with the approval of the tribunal, which shall make such order as it may deem fit. So, no one can change the public company into private company by simply passing a special resolution. So, they have to take the prior approval from the tribunal. Tribunal here it is the affiliated court, the affiliated judge or the affiliated court. So wherever the company is registered in their premises, one court will be there. From there, they have to take the permission that we are going to convert our company from public nature into private nature. So after the tribunal giving the approval, then only they can convert the public company nature into private company nature. Next, now we are going to see conversion of a private company into public company. Similarly, where a private company alters its articles by passing special resolution in such a manner that they no longer include the restrictions and limitations which are required to be included in the articles of a private company, then such company shall cease to be private company from the date of such alteration. So here the same procedure should be followed by the private company, but not that much of procedures to be followed by the public company. So what they are saying means, so when a private company decides to change into a public company, that it can simply do by passing a special resolution by altering it articles of association. Here they didn't mention that the private company should take the permission from the tribunal. But when a public company converting into a private company, it should take the permission from the tribunal and also alter its articles of association and also take the permission from all the stakeholders, everyone. So when coming into the private company, the conversion procedure is simple. It should not take the permission. No need to take the permission from the tribunal, but it should pass a special resolution by altering it articles of association. Next, filing with the registrar. See, every alteration of a every alteration of the articles and a copy of the order of the tribunal approving the alteration of articles in respect of conversion of public company into private company or private company into public company shall be filed with the registrar together with a printed copy of the altered articles within a period of 15 days in such manner as may be prescribed, so who shall register the same. Any alteration of the articles registered as above shall, subject to the provisions of this act, be valid as if it were originally in the articles. See, what are they saying is filing with the register. When a public company take a decision to change into private company, or when a private company taking a decision to changing into the public company, then it should file it with the registrar. So when the companies at the time of incorporation, they will file with the register all the required documents and every details. And also in the same way, when they are changing their nature, public into private or private into public, they have to change. They have to submit these changing details to the register of company within 50 days from the date they have took the decision. Okay. Next, this might come as a bit. Within how many days a public company changing into a private company should submit the details with the registrar? Then we can answer it as a 15 days. Next, large partnership to be registered as company, or when companies must be registered. According to Section 464 of the Companies Act 2013, no association or partnership consisting of more than 50 as per Rule 10 of the Companies Miscellaneous Rules 2015-14 shall be formed for the purpose of carrying on any business that has for its object the acquisition of the gain by the association or partnership or by the individual members thereof, unless it is registered as a company under this act or is formed under any other law for the time being in force. For example, if some people together, like more than 50 members together, are running a business, so then they are not legally valid to carry the business when the number exceeds to 50. So here the act is Companies Act 2013. What is saying is, no association or partnership consisting of more than 50 or shall be formed for the purpose of carrying on any business, so that has for its object the acquisition of gain by the association or partnership or by the individual member thereof, unless it is registered as a company. So if a partnership business contains more than 50 members, it should not carry the business in the partnership nature. It should be registered as a company. Then only it can carry the business. Above stated provisions shall not apply to. So what are the above provisions? Section 464 of the Companies Act 2013 says that if a partnership firm is carrying the business by more than 50 members, then it is subjected to register under the Companies Act. So otherwise it is not going to be conduct any business. That is what Section 464 of the Companies Act 2013 saying. But that provisions are not applicable for the following companies. Means the following companies can carry the business as partnership form even they are having more than 50 members. What are those business? One is Hindu undivided family carrying on any business, and the second one is an association or partnership if it is formed by the professionals who are governed by the special acts. So these both can carry the partnership business even they have more than 50 members without registering into a company. Next, every member of an association or partnership carrying on business in contravention of Ebola shall be punishable and shall also be personally liable for all liabilities incurred in such business, which will be an illegal association. So, whatever the rules given by Section 464 of the Companies Act 2013, if not followed by any partnership form, then the partnership business which is carrying under a business, if any liability is incurred, then all the partner members are subjected to that liability, and the government is not going to protect them. And whatever all the liabilities that are happened by that partnership business will be personally applicable to all the partners, and it is also called as an illegal association. Such a body will have no legal existence and it cannot be wound up under the act or even as an unregistered company. So it is not have any legal entity's status, and it is not wound up or it will be called as an unregistered company. Neither a member of it would be able to sue it, nor would it be able to sue the member. So that partnership form will loses all the powers it had. Like the partnership form cannot sue the members, or the members cannot sue the partnership. Nevertheless, a member who has paid any money to the association would be able to recover it from the director or agents or the association before the money so paid has been applied to an illegal purpose. So simply what they are saying, if a partnership firm which has more than 50 members, it is subjected to register under the Companies Act. If it not registered under the Companies Act, means whatever the powers that they have, they will lose. So that is what section 464 of Companies Act 2013 is saying. Next, incorporation of a company, formation of a company, how the company is formed. Persons who form the company are known as promoters. So the beginners who started the company, like Google is started by some people, Apple is started by some people, Flipkart is started by some people like Sachin Bansal and Binny Bansal. So they were called as the promoters. So it is they who conceive the idea of forming the company. They take all necessary steps for its registrations. So promoters should take all the necessary steps for registering the company. Section 3 of Companies Act 2013 deals with the basic requirement with respect to the constitution of the company. So section 3 of the Companies Act 2013 deals with all the basic requirements with respect to constitution of company. What should be there, what should be not there. So all these details are explained by section 3 of the Companies Act. Public company. So what are they have given different aspects for each company. What if it is a public company? What if it is in case of private company? What if in case of one person company? So they are giving the different aspects. First one, public company. In case of a public company, with or without limited liability, or any seven or more persons can form a company for any lawful purpose by subscribing their names to memorandum and complying with the requirements of this act in respect of registration. So if in case of a public company, 7% can form the company, okay, by giving their names in the memorandum of association and forming all the clauses and everything. So in case of a private company, in exactly the same way, two or more persons can form a private company. So in case of a private company, two or more persons can form the company. So in case of one person company, where the company to be formed is to be one person company. So in case of one person company, one person can form the company. So these are the mandatory rules. This can also come as bits. So in case of public company, how many members are subject to form the company? 7. In case of a private company, how many members are subject to form the private company? 2. In case of one person company, how many members are subject to form the company? 1. Like that. This can be asked as bits. If number of members reduce below the above stipulation and the company carries on business for more than 6 months, every member severally shall be liable to pay the debts of the company. So they have given section 3 of the Companies Act 2013 given some specific rules. If those rules are missed in the formation of a company and they carried the business for 6 months, more than 6 months, and whatever the liabilities occurs on the face of company, then those persons are subject to pay the liability. That is what section 3 of the Companies Act 2013 is saying. B. Procedural aspects of incorporation of company. So, while incorporating company, what are the procedures should be followed? Section 7 of the Companies Act 2013 provides for the procedures to be followed for the incorporation of a company. These provisions are to be read with the company's incorporation rules as amended. Section 7 says the procedures to be followed. What are the procedures? Filing of the documents and the information with the registrar. The first procedure is filing of documents and information with the registrar. For the registration of the company, following documents and information are required to be filed with the registrar, within whose jurisdiction the registered office of the company is proposed to be situated. Where the company is situated, there is a registered office. So with that registered office, the company is subjected to file the following all documents and everything. First one, the memorandum and articles of the company duly signed by all the subscribers to the memorandum. First one, the memorandum has to be filed, and the memorandum is also should be signed by all the subscribers who subscribe to it. Second one, a declaration by a person who is engaged in the formation of the company, an advocate, a chartered accountant, a cost accountant, or a company secretary in practice. So see, this is very very important line. A declaration by the person who is engaged in the formation of a company. So when the company is forming, they should receive a declaration from the following persons, like an advocate or a chartered accountant or a cost accountant or a company secretary. So these people who are qualified after your CMA, when you keep in practice, you will get an opportunity like this, the declaration opportunity. People who are starting a new company, they will come to you and ask, please give us a declaration because we are forming a company. So there they have to get the declaration from these people, and by a person named in the articles like director, manager, or a secretary of the company, that all requirements of this act and the rules made thereunder in respect of the registration and matters precedent or incidental thereto have been complied with. So the company section 7 of the Companies Act 2013 saying that So that a declaration should be received from an advocate, chartered accountant, or a cost accountant, or a company secretary in practice, or any one person, or by a person named in the articles of association, like director, manager, or secretary. What they have to give declaration that this company, when it's forming, is followed all the rules and regulations that it meant to be. So that type of declaration should be given. And rule number three, procedure number three is a declaration from each of the subscribers to the memorandum and from the persons named as the first directors, if any, in the articles of association. So those persons who are subscribed to the memorandum are also from and also from the persons named as the first directors. From them also the declaration should be taken. What is the declaration? Is he is not convicted of any offense in connection with the promotion, formation, or management of a company. So when the company is promoting or forming or management, he is not convicted like the declaration, and he has not been found guilty of any fraud or misfeasance or by any each of the duty to any company under this act or any previous company law during the last 5 years. So when he be acting as a promoter or when he acting as a director, he subscribed to the memorandum. In his entire history should be clean. He should not subjected to found guilty, or he should not involved in any case, illegal cases. So that type of declaration should be given by him. And that all the documents filed with the register for registration of the company contain the information that is correct and complete and true the best of his knowledge and belief. So while forming the company, that he will be acting as one of the promoter, or he will be acting as one of the director. So on the basis of his knowledge, whatever the documents, whatever the files that are filing for the registration of company, they are all clean and good. That in his knowledge, that type of declaration in written words has to be given by him also. Next, D, the address for corresponding till its registered office is established. Okay. Filing of the documents and information, the address for the corresponding till its registered office address, the address should also be given. The particulars, names including surnames or family names, residential address nationally of every subscriber to the memorandum, along with the proof of identity, and in the case of a subscriber being a body corporate, such particulars as may be prescribed. Whoever acting as the subscribers of the memorandum, or whoever acting as the directors of the memorandum, they have to give in their address details, residential address, and every identity details for the register office. The particulars, names including surnames or family names, the director identification number, residential address, nationality of the persons mentioned in the articles of the first directors of the company, and such other particulars including the proof of the identity as may be prescribed. So the director identification number and all the details. So whatever the addresses, whatever the details that are proving their existence, they should give in all of them to the register of the company. Okay. Next, the particulars of the interests of the persons mentioned in the articles as the first directors of the company in other forms or bodies corporate, along with their consent to act as directors of the company in such form and manner as may be prescribed. So what they are saying means there in the articles of association or memorandum of association, it is given that these are the directors of, these are the persons who are acting as the promoters of the company. In the, it is mentioned in the articles of association. From there, and also they have to give their consent. Yes, we are on our interest, we are acting as directors for this company. We are going to take each and every responsibility of this company on behalf of this company. So they have to give that kind of declaration and give their director identification number and make a sign on that papers and submit to the registrar. So particulars provided in this provision shall be of the individual subscriber and not of the professional engaged in the incorporation of the company. The company's incorporation rules 2014. So section procedural aspects of incorporation of the company. So in this, as per the section 7 of the Companies Act 2013, filing of the documents and information with the registrar. So these are the documents. So should be filed with the registrar under section provision 1. Okay. Next, Issue of certificate of incorporation on registration. After once the all the required documents is filed with the registrar, then what they do is issue of certificate of incorporation on registration. The registrar, on the basis of the documents and information filed, shall register all the documents and information in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this act. So after getting all the required documents under subsection 1 of section 7 of Companies Act 2013, if the registrar is satisfied with everything, then he will issue a certificate of incorporation on registration. Number 3, 7 clause 3 provision, allotment of corporate identity number. On and from the date mentioned in the certificate of incorporation, the registrar shall allot the company a corporate identity number, which shall be distinct identity for the company and which shall be also be included in the certificate. So after issuing certificate of incorporation on registration, so then a corporate identity number SIN will be issued to the company. Okay, this is the procedure. 4. Maintenance of copies of all documents and information. The company shall maintain and preserve at its registered office copies of all documents and information as originally filed till its dissolution under this act. So, after filing all the documents with the registrar, the company shall maintain and preserve at its registered office copies of all documents and information as originally filed. Okay, whatever the documents it filed at the register, the company at its registered office, the company shall maintain all the copies of its original documents. Okay. 7 clause 5, what furnishing of a false or incorrect information or a suppression of material fact. If the company at the time of its registration, if it submitted any incorrect information or if it changed the matter material fact, so from one into another, then it going to face some punishments. They are, if any person furnishes any false or incorrect particulars of any information or suppresses any material information of the which he is aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable for the action under section 447. Same provisions are also applicable for the promoter and first director in this regard. So, for at the time of registration of company, if they provided any false document or changed the material fact or the suppression of material fact, they are going to be punishable under section 447 of the Companies Act 2013. So, this is what under section 7, procedural aspects of incorporation of company, section 7 of the Companies Act 2013. So when they asked the question like what are the procedural aspects of incorporation of a company, everyone should remember that section 7 of the Companies Act deals with the procedural aspects of the incorporation of a company. They are subject to write the following headlight points like number 1, 7 clause 1, filing of documents and formation and the information with the register. Sub 7 subclause 2, issue of certificate of incorporation on registration. 7 subclause 3, allotment of corporation identity number SIN. 7 subclause 4, maintenance of copies of all documents and information. 7 subclause 5, furnishing of a false or incorrect information or suppression of material fact. Okay. Steps for the formation of a company. What are the steps for the formation of a company? The Companies Incorporation Amendment Rules 2020 with effect from 23rd February 2020 introduced a new web form SPIC plus for incorporation of the companies replacing the old e-form SPIC. SPIC is an integrated web form offering 11 services by various concerns, central government departments and 3 state government Maharashtra, Karnataka, and West Bengal, thereby saving as many procedures, time, and cost for starting a business in India. As per Rule 38 of the Companies Incorporation Rule 2014, the application for incorporation of a company shall be made. So these are all things we no need to study a thing. So these, let's have a look into this. The application under shall be accompanied from Agile Pros Incorporation 35 containing an application for registration of the following numbers, namely okay, this is all not required. Okay, establishment of central security center. The central government has established a central security center for carrying out scrutiny of straight through process STP e-forms filed by the companies under the Companies Act 2013 and the rules made thereunder, which has come into the force March 23, 2013. So this is all the procedures, whereas formal procedures which are not going to that much important for us. So now we are coming into the main deal, that is the formation of one person company. So it is a very important topic. The memorandum of one person company shall indicate the name of the other person who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. So one person company is formed by single person. So in the memorandum, it should be clearly mentioned that if this one person is subjected to what is that, face any accident or he become incapacity to deal the company, then on behalf of this person who is going to deal the company, that person's name should be given in the memorandum. The other person whose name is given in the memorandum shall give his prior written consent in prescribed form, and the same shall be filed with the register of the companies at the time of incorporation. We cannot give any member's name in the memorandum on our own choice. So, for example, I am starting a one-person company, and I have my brother or some of my relative, and I am giving his name as nominee on my behalf. He is going to act. I can't give like that. I have to go approach to him and ask his consent. So this is the situation. So on behalf, when I am facing a critical issue, so on my behalf, are you going to act, are you going to take all the responsibilities of my company? So then if he says yes, he have to write the consent, yes, on behalf of this person, when he facing any issues, I am going to take the responsibilities of the companies, that like he have to give some written consent, and it should be attached to the memorandum. Then his name can be given in the memorandum. Such other person may be given the right to withdraw his consent. So the memorandum of one person company may at any time change the name of such other person by giving notice to the company, and the company shall intimate the same to the registrar. So the memorandum, I can withdraw that the particular person nominee name at any time. So after giving a notice to the registrar, so I have to give the notice to the registrar. I am giving, removing this persons on behalf of me. I am keeping some other persons on my behalf. So this is the notice I am going to give. If that type of written consent should be given to the registrar, then we can change the nominee. Any such change in the name of the person shall not be deemed to be an alteration of the memorandum. So changing of the nominee or not is not called as changing of memorandum or alteration of memorandum. No person shall be eligible to incorporate more than one person company or become nominee in more than one such company. Okay, so what they are saying is, if a particular person is acting as a nominee for my one person company, he is not subjected to act as a nominee for another one person company. So one person can act as nominee for only for one person company. So what they are saying is, a person should act as nominee for only one person. In case of one person company, he is not subjected to act as a two to three one person companies as nominee. No minor shall become the member or nominee of the one person company or can hold a share with the beneficial interest. Such company cannot be incorporated or converted into a company under Section 8 of the Act, though it may be converted into a private company or public company in certain cases. The procedure of conversion is given in the rules 6 and 7 of the company's rules 2014. What they are saying is, no minor should act as nominee on behalf of a person in the one person company. Such company cannot carry out non-banking financial investment activities, including investment in securities or any body corporate. So, a one-person company is not supposed to carry the non-banking financial investment activities. So, next, one-person company cannot convert voluntarily into any kind of company unless 2 years have expired from the date of the incorporation, except where the paid up share capital is increased beyond 50 lakhs or its average annual turnover during the relevant period exceeds 2 crores. So what they are saying is, a one person company cannot voluntarily convert into any company unless 2 years have expired from the date of its incorporation. If I started a one person company on this particular year 2024, and if I want to convert into some another company, I should wait for 2 years, like 2025 2026. After 2026 only I can convert this one person company into any nature. But they are giving a B, what is that, relief. If my company's capital is, except where the paid up share capital is increased to 50 lakhs, beyond 50 lakhs, if my paid up capital is beyond 50 lakhs, at the time of beginning I started the company with 10 lakhs. So and then I have to follow the rules, and I have to wait for the 2 years. If my paid up capital is increased to 60 lakhs or 70 lakhs, and also or its average annual turnover or average turnover during the relevant period, and during this relevant period, like in 2024 I started the company, and the turnover of my company is also increased to 2 crore, or my paid up capital is also stay increased from 10 lakhs to 17 lakhs. If any one of these condition is satisfied, then I can change the nature of the one person company to another company. If these two conditions are not satisfied means, then I have to wait for the 2 years to complete my change the status of one person company into another company. Next, if one person company or any officer of such company contravenes the provisions, they will be punishable with fine which may extend to 10,000 and with further fine which may extend to 1,000 for every day after the first during which such a contravention continues. If I did not follow the rules which are given, which are stated above, like if I keep any nominee, any minor as my nominee, or if I change the status of the company before 2 years, then I subjected to punishment. Okay, with fine which may extend to 10,000 and with any further fine which may extend to 1,000 for every day. So until in how many days I continues this not following the provisions for each day, I am supposed to get 1,000 rupees fine every day. Rule 3 of the Companies Incorporation Rules 2014 says only a natural person who is an Indian citizen, whether resident in India or otherwise, shall be eligible to incorporate a one person company. Okay, so what their rule 3 of the Companies Incorporation Rules 2014 says that only a natural person who is an Indian citizen, whether resident in India or otherwise, shall be eligible to incorporate a one person company. They are only subjected to form the one person company, and or otherwise shall be a nominee of the sole member of one person company, where a natural person being the member in one person company in accordance with this rule becomes a member in another such company by virtue of his being a nominee in that one person company. Such person shall meet the eligibility criteria specified in Rule 3 Clause 2 within a period of 180 days, where a natural person being a member in one person company in accordance with this rule becomes a member in another such company by virtue of his being a nominee in that one person company. Such person shall meet the eligibility criteria specified in 3 Clause 2 within a period of 180 days. So earlier I said that a person who is acting as a nominee for one person, he is not supposed to act as one person for another company. But what they are saying is, what the rule mentioned in Rule 3 Clause 2, if he is satisfied, if he meets the eligibility criteria within 180 days, he can also act as one person, a nominee for another person also, but he should meet the eligibility criteria within 180 days. What they are saying here, effect of registration. So what is the effect of registration? So many people asks, what are the effects of registration, what are the benefits of registration? So the Companies Act says that on incorporation, the company shall be a body corporate by the name contained in the memorandum. Such a registered company shall be capable of exercising all the functions of an incorporated company under this Act, and having a perpetual succession and a common seal with power to acquire, hold, and dispose of property, both mobile and immobile, tangible and intangible, to contract, and to sue and be sued by the said name. So it will be an artificial juristic person. So if a company registered means, it will get lot of benefits, like it can sell the property, it can buy the properties, it can sue the persons, and it also get sued. So these all powers will be come to the artificial person. It will be given a separate identity as per the Companies Act 2013. Whatever the powers that have a natural person, those powers can also be gained by that artificial person also. So those were the effects of registration. Next, certificate as a conclusive evidence. Section 35 of 1956 Act provided for a certificate of incorporation given by the registrar on registration. Though 2000 Act do not have a section to replace the earlier section, certificate of incorporation is accepted as conclusive evidence of existence of the company by all judicial and administrative authorities. So whatever the provisions that have that contained in 1956 Companies Act, those provisions are also going to be accepted in Companies Act 2013. So what they are saying is, certificate of incorporation is accepted as a conclusive evidence of existence of a company by all judicial and administrative authorities. Effect of memorandum and articles. So what are the effects of memorandum and articles? As per section 10 of the Companies Act 2013, where the memorandum of articles, so when registered, shall bind the company and the members thereof to the same extent as if they respectively had been signed by the company, and by each member, and an agreement to observe all the provisions of the memorandum and articles and of the articles. All the money is payable by any member to the company under the memorandum of articles shall be a debt due from him to the company. So whatever the conditions, whatever the rules and regulations given in the memorandum, so they have to follow all of them. Whatever the monies, whatever the paid up capital are accepted by the members that they are going to pay to the company, they have to pay at any cost. As a result, a number of legal relationships are formed between different parties and the company, which are described below. So, if a company have a memorandum and articles, then it will have the following benefits, like between the members. Between the members and the company, what are the benefits? Means the memorandum and articles constitute a contract between the members and the company. In consequence, the members are bound to the company under a statutory convenient. So a bond is formed between the members and the company. If any typical situation is came between happened between the members and the company, then this bond acts as a settlement and it will settle it between the members intersection. In case of Wood versus Odisha Waterworks Company, Sterling J. observed, the articles of association constitute a contract not merely between the shareholders and the company, but between each individual shareholder and every other. So, what they are saying is the articles of association says that it not only carries the contract between the members and the company, but it also carries the contract between the every member. Okay, so this is proven in the case Wood versus Odisha Water Works Company. So a person, people who are working for a company, there is a contract between them and the company, and there is also a contract between each and every person. If any mistake happens at the time of running of a company, then everyone are subjected to that mistake and everyone are responsible in solving that mistake between the company and the outsiders. The memorandum and the articles do not constitute a contract between the company and the outsiders. Neither the company nor the members are bound by the articles to the outsiders, since this constitute a contract between the members interests and the outsiders is not a party to the articles. He may be named therein. So whatever what is they saying is, so the memorandum and articles also act as a contract between the company and all the vendors who are coming into the contract with the company. If any mistake happens, they are all subjected to that mistake. They are all responsible in clearing that mistake. So if a company have a memorandum and association, it acts as a strict rules between everyone, every member of the company. Whenever a mistake happens, so based on this memorandum and articles, they are going to show a solution. Nonetheless, an outsider is entitled to assume that in respect of contract entered into with him, all the formalities required to be carried out under the articles or memorandum have been duly complied with. Royal British Bank versus Torcon. So what they are saying means, if any person enter into a contract with any company, he is subjected to follow all the rules and regulations without mentioning them separately. So if I am the person whoever entering into a contract with a company, then I should subject to follow all the rules and regulations that are meant to be followed by the company. So this is what explaining by Royal British Bank versus Tarcon. Doctrine of ultra-wires. Directors of the company cannot perform something which is beyond the scope of memorandum. A transaction may be good in law but may not be within the powers of the company, and hence ultra-wise the company. So whatever the powers, whatever the responsibilities given in the memorandum, the directors should follow those and they only perform the duties up to what is mentioned in the memorandum. They can't perform beyond that. Shareholders, while drafting the memorandum, have already decided the outer boundaries both for themselves and also for the board of directors. Shareholders can decide the change or modify the objects and other clauses of the memorandum, but as long as it is not done, they cannot overshoot the existing memorandum provisions with which the company is registered. So, but the shareholders have the right to change the some clauses, something, some only some content in the memorandum, but they cannot change the entire the object of the memorandum. They can make small adjustments and something, some rules and regulations they can change, but they don't have the change the face of the memorandum, which is which is started at the which is filed at the time of starting of the company. Okay, there may be an action taken by the board of directors but is permissible by the company. In such situation, company may ratify the action of the board. However, ultra-vires action by the company cannot be ratified even when all the members agree to do that. Okay. So board of directors can take some actions. but those actions are permissible only on the ratification by the company. Here, the company means all the shareholders. So, whenever board of directors have taken any new change, then it should be accepted by the shareholders. Only on acceptance of the shareholders itself, the new act can be taken into existence. Commencement of the business, etc. As per section 10A, read with rule 23A of the company's incorporation rules 2014, every company incorporated after the commencement of the company's amendment act 2019 and having a share capital shall not commence any business or exercise any borrowing powers unless. So what are they saying means, so having a share capital shall not commence any business or exercise any borrowing powers. So company shall not commence any business or shall not borrow any money unless they have the following things. What are they? A declaration in form incorporation 1020A is filed by the director within a period of 180 days of the date of incorporation of the company in such form and verified by a company secretary or a chartered accountant or a cost accountant in practice with the register, and that every subscriber to the memorandum has paid value of the shares agreed to be taken by him on the date of making of such declaration. So whenever company is making any new implementation or whenever company taking any new decision, so regarding it borrowing some money from outside or regarding it is going to start after incorporation, regarding it is going to start a business on the on the name of this company, they have to take the declaration, and their move is going should be accepted by the chartered accountant in practice or company secretary in practice or a cost accountant in practice. The company has filed with the registrar a verification of its register office in form incorporation 22 as provided in subsection 2 of section 12 of the Companies Act 2013. So when the company is commencing any business or it is taking any borrowing from outside, it has to file the registrar regarding the same thing. So if case of a default, the company shall be liable to a penalty of rupees 50,000, and every officer who is in default shall be liable to a penalty of 1,000 rupees for each day during which such a default continues but not exceeding the amount of 1 lakh. If the company is not following the above provisions and it's starting the business on its own or it taking the loans on its own, then it is subject to a penalty of 50,000, and the officer who is in such involved in such a wrong procedure, he is also liable to fine of rupees 1,000 per day until which the comments and this illegal activity or this offensible activity continues, but his total punishable amount is not going to exceed rupees 1 lakh. Next, where no declaration has been filed with the register under clause A of subsection 1 within a period of 180 days of the date of the incorporation of the company, and the registrar has reasonable cause to believe that the company is not carrying on any business or operations, he may, without prejudice to the provisions of subsection 2, initiate action for the removal of the name of the company from the register of the companies under chapter 18. So if a company is incorporated by following all the procedures and everything, and it is planning to commence a business or it is planning to borrow some money from the outside, so when it got that idea, it has to file with the registrar within 180 days. So if it is not following those rules and if it is not doing all these things, then the registrar have the charge to remove the company name from its registrar. Okay, registered office of a company. Section 12 of the Companies Act 2013 seeks to provide for the register office of the company for the communication and serving of necessary documents, notices, letters, etc. The domicile and the nationality of a company are determined by the place of register office. This is also important for determining the jurisdiction of the court. So a company existence is determined by its registered office. So for if a company is registering at some place, then it can be called its place of business. So where is the registered office of the company, it is called as its place of business. So if anyone want to send any notices or any file any cases, they can take the registered office of the company's address as its address. So register office means from the 15th day of the incorporation and at all times thereafter, a company shall have a registered office capable of receiving and acknowledging all communication and notices as may be addressed to it. So after from the 15th day of of its registering, it should have a address to communicate. If anyone want to send any notice or if anyone want to expect something from the company, means they can send it to its registered office. Verification of registered office. The company shall furnish to registrar verification of its registered office within a period of 30 days of its incorporation. The form to be filed in Corporation 22, authorities can ask for any documents which gives the right to possession of the office space. For example, so after the company is registering at one place, it has to send its registered office address to the registrar. Okay, so, for example, one company is there; it is registering in the Hyderabad. So, the address of the company is can call as its registered office in Hyderabad. So, the company has to send all other details of its registered office to the registrar. Okay, and the registrar can ask further more details in proving its registered office existence. Labeling of the company. Every company shall paint or affix its name and the address of its registered office and keep the same painted or affixed on the outside of the every office or place in which its business is carried on in conspicuous position in legible letters, and if the characters employed are not those of the language or in general use in that locality, then also in the characters of that language. So a company should have some logo. Company should write its registered office name in specific format, which format is accepted in that registered office location place. For example, if a company is registered in Hyderabad, there should be the office name should be given in three languages. Like one is in Urdu, one is in English, and one is in Telugu. So the same whatever the names that is given in the given to the registrar, the same details should be fixed at the outside of the office. Okay, for example, some company is there, it is located in Hyderabad. Whatever the names that is given to the registrar, the same fonts, the same letters should also be kept at the outside the office by the company. Labeling of the company. Clause B, have its name engraved in legible characters on its seal. The Companies Amendment Act 2015 has deleted the requirement of having common seal compulsorily. C, get its name, address of its registered office and the corporate identity number along with the telephone number, fax number, if any, email and website address, if any, printed in all its business letters, bill heads, letter papers, and in all its notices and other official publications. Every company will have some addresses. All those like telephone number, fax number, email, address, everything should be given printed on its bill heads, invoices, and every paper that related to that company. Next, habits is a name printed on hundis, promissory notes, bill of exchange, and such other documents as may be prescribed. This is the same. Name changed by the company. Where a company has changed its name during the last 2 years, it shall paint or affix or print along with its name the former name or names so changed during the last 2 years. For example, one person started a company and within 2 years or after 2 years he changed the company. Then what he should do is he should also give the previous name and also give the current name in the board of his company. Next, in case of a one-person company, the words one-person company shall be mentioned in the brackets below the name of such company, wherever its name is printed, affixed, or engraved. Can be understand. Notice of change to registrar. Notice of every change of situation of registered officer. Notice of every change of situation of registered office verified in the manner prescribed after the date of incorporation of the company shall be given to the registrar within 15 days of the change. So who shall record the same? So this is applicable to the change in the registered address of the company. So within the local limits of the village, town or city or remaining within the jurisdiction of the same with the of register of company. For example, at Hyderabad, one company is established. Its its location is at Gachibowli. The same details is given to the registrar of the companies. And due to some flood situations or due to some earthquakes or due to some any local political activities, the company is planning to change its location from Gachibowli to Habsiguda. So then, after changing its location, then the same should be communicated to the registrar within the 15 days of change. So when the company is planning to change its base location, its location from Gachibowli to Habsiguda, it has to give the change the details to the register within 15 days. So change by passing of special resolution. The registered office of the company so shall be changed only by the passing of special resolution by a company. So in case of an existing company outside the local limits of any city, town or village where such office is situated at the commencement of this act or where it may be situated later by virtue of special resolution passed by the company, or in case of any other company outside the local limits of any city, town or village where such office is first situated or where it may be situated later by virtue of special resolution passed by the company. So Special resolution. So the company, when it is planning to change its registered office from Hyderabad location to another location, it has to pass some special resolution. After passing the special resolution, only it can change the registered office. So change of registered office outside the jurisdiction of register, where a company changes the place of its registered office from the jurisdiction of one register to another register. Jurisdiction of another register within the same state, so where such change is to be confirmed by the regional director on an application made by the company. So for Hyderabad, what all the companies who are planning to register their offices in Hyderabad, these are all come one under one person. And if they are planning to change their office to another place, where it comes under the another officer, okay, so then what it has to do is it had to make it where a company changes the place of its register office from the jurisdiction of one register to the jurisdiction of another register within the same state, there such a change is confirmed by the regional director on an application made by the company. So first of all, the company had to make an application to the regional director. So then only after the regional director accepts it, if the company is planning to situate in Telangana state, but it is planning to move from its register office from a Hyderabad location to another location, where the another location comes under the jurisdiction of another register. So then the company first have to make an application to the regional director, and once the regional director accepted its request, then it can change the jurisdiction of to another register. Communication and filing of confirmation. The confirmation of change of registered office from jurisdiction of one register to another register within the same state shall be communicated within 30 days from the date of the receipt of the application by the regional director to the company. So, under the company shall file the confirmation with the registrar. So, within a period of 60 days of the date of the confirmation, who shall register the same. So, communicated within 30 days from the date of the receipt of the application by the regional director to the company. Next, the register of companies of new jurisdiction shall certify the registration within a period of 30 days from the date of the filing of such confirmation. As of now, Tamil Nadu and Maharashtra are the two states where there are two registers of the companies are opening. The jurisdictions of the respective registers of the companies are notified. This is simple as you can understand all those things. Okay. Certificate and conclusive evidence of compliance of requirements of this act. The certificate shall be conclusive evidence that all the requirements of this act with respect to change of registered office have been complied with. The change shall take effect from the date of certificate. So what they are saying is a certificate and conclusive evidence of compliance of requirements of this act. The certificate shall conclusive evidence that all the requirements of this act with respect to change of registered office have been complied with, and the change shall take effect from the date of the certificate. So whenever they changing to another jurisdiction, so they have to comply with all the rules and regulations what are they followed in that jurisdiction from the date of the change only. In case of default, if any default is made in complying with the requirements of this section, the company and every officer who is in default shall be able to a penalty of 1,000 for every day during which the default continues, but not exceeding rupees 1 lakh. In case of register is convinced with evidence the company is not carrying on any business, he may initiate action to strike off the name of the company. If the registrar is satisfied that the company is not carrying on any business and he is satisfied with all the evidences submitted to him, so then he can strike off the name of the company from the registrar. Act to override the memorandum and articles, etc. So, according to Section 6 of the Companies Act 2013, the provisions of this Act shall have the overriding effect on the provisions contained in memorandum or articles or an agreement or in resolution passed by the company in general meeting or by its board of directors, whether they are agreed, whether they are registered, executed, or passed before or after the commencement of this act. Any provision contained in any of the above mentioned document shall be void to the extent to which it is inconsistent to the provisions of the act. So, if any memorandum or articles of association is not following the rules and regulations that are mentioned in the Companies Act 2013, so if they feel that the memorandum and articles of association is not following the rules given by the Companies Act, then they can strike off the memorandum and articles. Memorandum of Association. The Memorandum of Association of a company is in fact its charter. It defines its constitution and the scope of the powers of the company with which it has been established under the Act. A memorandum is a public document under Section 399 of the Companies Act 2013. Consequently, every person entering into a contract with the company is presumed to have the knowledge of the conditions contained therein. Section 4 of the Companies Act 2013 seeks to provide for the requirements of the respect to memorandum of a company. So, memorandum. What a memorandum of association contains. A memorandum of association contains all the conditions that should be followed by everyone who are working for the company and on what conditions the company is functioning. All these details are will be mentioned in the memorandum of association. So in detail they are giving that contents of memorandum of association. The following contents are mentioned in the memorandum of association. So the memorandum of a company shall state the name of the company with the last word limited in case of a public limited company, or the last words private limited company in case of a private limited company. Understood. The state in which the registered office of the company is to be situated. In which state. So the registered office of company is situated is also given in the memorandum. The objects of which the memorandum is proposed to be incorporated, and any matter considered necessary in furtherance thereof. If any company has changed its activities which are not reflected in its name, so it shall change its name and line with its activities within a period of 6 months from the change of activities after complying with all the provisions as applicable to the change of name. So next, the liability of the members of the company, whether limited or unlimited, and also state. So in case of a company limited by shares, and the liability of its members is limited to the amount unpaid, if any, on the shares of held by them. So, in case of a company limited by guarantee, the amount up to which each member undertakes to contribute. So, to the assets of the company in the event of its being wound up while he is a member, or within one year after he ceases to be a member, for payment of the debts liabilities of the company, or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and to the costs, charges, expenses of winding up, and for adjustments of the rights and contributes among themselves. So what are they saying is, in memorandum every detail is mentioned. If a member is acting for the company, what is his responsibilities, what is his duties, what is his share for the company. In the event of winding up, if any liability occurs to the company, what is his share in the liability. So what are the winding up charges applicable to him. So what are the, if anything is changed at the time of in the memorandum, from the date of its incorporation to another time, it should be reflected within 6 months in the memorandum. Okay, all these details are giving. So what every detail, whatever the company is on which condition the company is going to work, that should be mentioned in the memorandum of association. So, in case of a company having a share capital, the amount of the share capital with which the company is to be registered, and the division thereof into the shares of a fixed amount, and the number of the shares which the subscribers to the memorandum agree to subscribe, so which shall be not less than one share, and the number of the shares each subscriber to the memorandum intends to take indicate opposite in his name. So, in case of one-person company, the name of one-person company who, in the event of the death of the subscriber, shall become the member of the company. So what are they saying is, so in case of a company, it is formed with the share capital. How many members are subscribed to that share capital? So how many members are in there in that company? In the memorandum, all the names should be listed, and in opposite to their name, how many shares he is held. If a person holds 5 shares, in front of his name, the 5 shares should be mentioned. If a person holds 10 shares, in front of his name, the 10 shares should be held. So, in case of one-person company, the name of the person who is in the event of the death of the subscriber. In case of a one-person company, it is there. So, in the memorandum of one-person company, in the event of the death of that particular person, who is going to act as nominee in his place. So, that name also should be given there. Next, applying for the name of the company. So there are different names for different companies. For example, Genpact, for example, Accenture, and Infosys. So there are different names for each company. So how to get a name for the company? How to apply for that particular name? The procedure is, the name stated in the memorandum shall not be identical with or responsible to nearly to the name of an existing company registered under this act or any previous company law. If a company is formed and it is planning to have a name, so that name should not be identical to another company. For example, Genpact India Limited is there, it is a company. So in that company, very close to that company, another name is not should be formed. Genpact Genesis, Genpact High Level, Genpact Low Level, Genpact India. Like that, another name should not be formed close to that particular company. Whatever the name that the new company is planning to have, it should be different from all other existing companies. Okay, so be such that its use by the company will constitute an offence under any law for the time being in force and is undesirable in the opinion of the central government. So registration of the name of the company without affecting the provisions. So a company shall not be registered with a name which contains. So a company is not subject to keep a name which is undesirable in the opinion of the central government and also shall not constitute a name which is offensible under any law. Okay, the company should not plan to keep a name that is not going to work in the eyes of law, that is not going to work in the eyes of central government. And also they were saying registration of a name of the company without affecting the above provisions, a company shall not register with a name which contains. So a company should not register a name by following names. Any word or expression which is likely to give the impression that the company is in any way connected with or having to patronage of central government, state government, any local authority, corporation, body constituted by the central government, or any state government under any law for the time being in force. Any such word or expression as may be prescribed unless the previous approval of the central government has been obtained for the use of any such word or expression, whereas guidelines have been issued on viability and the use if names and are stipulated in companies incorporation rules. So the company is not subjected to keep any name as stated above. Requirement for the reservation of the name of the company. A person may make an application for the reservation of the name through web service to the registrar, central registration center, with which may either be approved or rejected for the name of the proposed company or the name to which the company proposes to change its name. For example, I am planning to start a company and I have a unique name. There might be chances that this unique name can be guessed by some other people. Then what I should do? I have to apply to the register that I am planning to keep such name for my company. So I have to register the name with the company. So then this company name, if it is okay, if it is under the provisions of the Companies Act 2013, that the registrar will accept my name and give that name to my company. Even if in case if some other person have the same thought regarding the company name and he keep the application for his company the same name, then the registrar will let him know that this company is registered by the particular person for his company. So you are not authorized or you are not allowed to keep this name for your company. Like that, benefit will be there for us when we apply for the name for the with the registrar. The name shall be registered for 20 days from the date of approval in case of new company and 60 days in case of existing company. So what they are saying is the name shall be registered for 20 days from the date of approval. So if I'm planning to keep my company name within 20 days means I have to start applying the name for within these days. So if my company is new, if it is an already an existing company, if I want to plan my company name new name, so within 60 days means then I have to apply the company name by today only. Okay, and this can be also a bit. So within how many days a new company can register its name and within how many days an existing company can register its name means 20 days and 60 days, where after the reservation of name it is found that the name was applied by furnishing wrong or incorrect information, then if the company has not been incorporated, the reserved name shall be cancelled and the person making application shall be liable to a penalty extending to rupees 1 lakh. So if your name is formed with fake details and if your name is formed with incorrect details, then the company going to penalize him with the punishment amount of 1 lakh. If the company has been incorporated, the registrar may, after giving the company an opportunity of being heard, so either direct the company to change its name within the period of 3 months after passing an ordinary resolution, take action for striking of the name of the company from the register of the companies, or make a petition for the winding up of the company. So a registrar can giving him a reasonable opportunity of being heard can direct him to change the name of the company within 3 days or ask him to cancel the name and keep another name. If he is not following the rules as given by the Companies Act 2013 and keeping the name as required by him, if it is not binding with the rules means then the registrar can give him a reasonable opportunity of being heard and direct him to change the new company or strike the name asked by him. Extension of reservation in certain cases. Upon payment of the fees provided below the through the web services available with www.ministry-of-corporate-affairs-mca.gov.in, the registrar shall extend upon payment of the fees provided below through the web service the period of a name reserved under Rule 9 by using web service. So these are the details. What they are saying is extension of reservation of name. So in case of certain cases, he can register the name for a particular period of time by paying some fees. So the details are given here in detail. The period of the name reserved under Rule 9 by you by using web services, simplified pro forma for incorporating company electronically. 40 days from the date of the approval on payment of fees, 1,000 rupees before the expiry of 20 days. So these are all the details you can study. If a particular person pays the certain amount of the fees like 2,000, 3,000, 2,000 for 60 days and 3,000 for 60 days. So after the expiry of for 2,000, after the expiry of 40 days, from 40 days, if you still want to extend the name, means for 60 days he have to pay the fees of 2,000, and after the expiry of 20 days from the 60 days he have to pay the fees of 3,000 in order to reserve the name for him. Next, 1.1. Yeah. Alteration of the memorandum. It is likely that with the passage of time, the company will grow or diversify. Shareholders therefore have the right to modify nay issues which they could not foresee initially. So every time everything will changes based on the period. So at the beginning of the company, the based on some terms and conditions, the articles of association or articles or memorandum will be formed. After completing of some period of time, the company might have thought regarding changing of memorandum. So when the time changes and when the company grows based on various issues, the company decides to change the memorandum objectives or memorandum conditions. So this is done by alteration of the memorandum and articles as and when needed. Section 13 of the Companies Act 2013 provides the provisions that deal with the alteration of the memorandum. The provisions say that. So Section 13 of the Companies Act 2013 gives the power for every company can alter their memorandum. Every company formed initially with some objectives of memorandum and some objectives of articles of association. After completing some period of time, based on the changes, based on the requirement, they can alter. This power gives by the Companies Act 2013 under Section 13. So what are the provisions? The provision says that so company may alter the provisions of its memorandum with the approval of the members by a special resolution. When a company thinks to change its memorandum, it can change by passing a special resolution. Any change in the name of a company shall be effected only with the approval of the central government in writing. So a company can change its name, but only after getting approval from the central government. However, no such approval shall be necessary where the change in the name of the company is only the deletion of therefrom or addition thereto of the word private on the conversion of one classes of companies to another classes. So if the changes are not that much of big, entire name is not going to change, but they are making some additions or deleting some names, then it can change without getting approval from the central government. So like for example, Genpact Solutions India Limited. So they thought that they have to remove the solutions name. Then they can keep name as Genpact India Limited without getting approval from the central government. If the changes are very minor, then no need to get the approval from the central government. If they thought that they want to change the entire name into a different name, then they have to get the approval from the central government. Okay. So the change of the name shall not be allowed to a company which has defaulted in filing its annual returns or the financial statements or any document due for filing with the registrar, or which has defaulted in repayment of the matured deposits or debentures or interests on deposits of debentures. So what they are saying is under Section 13 of Companies Act 2013, the company which fails to meet its deadlines, like repayment of interest on debentures, like filing of its returns with the registrar, if the company fail to meet these all necessary requirements, then they don't have the power or they don't have the right to change their name under Section 13 of the Companies Act 2013. Next provision. On any change in the name of the company, the registrar shall enter the new name in the register of the companies in place of the old name and issue a fresh certificate of incorporation with the new name, and the change in the name shall be complete and effective only on the issue of such a certificate. When a company wants decided to change its name, then the registrar, where the company used to register their company, the registrar have to erase the old name. In that old name place, they have to write the new name, and after writing the new name, the registrar shall issue the certificate of incorporation. When the certificate of incorporation is issued by the registrar, then only the name complete, the change of name is completed. Next, the alteration of the memorandum changing the place of registered office from one state to another shall not have any effect unless it is approved by the central government. They are also saying that alteration of memorandum means changing of memorandum or changing the place of registered office from one state to another state shall not have any effect if it is approved by the central government. If the central government have given the approval for anything that is needed by the company, then there will be no effect. If the company does anything it needed without the approval of central government means, then it will be an issue for the company. The central government shall dispose of above shifting within 60 days, satisfying itself that the alteration has the consent of the creditors, debenture holders, and other persons concerned with the company, or the sufficient provision has been made by the company either for the due discharge of all its debts and obligations. So, central government shall dispose of the above shifting within 60 days. So, the company shall change all the requirements, all its name or its place of business only after the getting the approval of its shareholders, stakeholders, creditors, debenture holders. So if it is changed without all of this approval means it will be an issue for the company. Next, a company shall file with the registrar such order of central government along with the shareholders resolution. Where an alteration of the memorandum results in the transfer of the registered office of a company from one state to another, a certified copy of the order of the central government approving the alteration shall be filed by the company with the register of each of the states within such time and in such manner as may be prescribed who shall register the same. So, whenever the company decides to alterate its memorandum, in the process of alteration, the company planning to switch its register office from one state to another state, then the company then the company duty is an order accepting by the central government of its change in the place of a register office from the one state to another state shall be submitted by the company for the two states. So the previous one and the next coming new one, that we have the approval of the central government that in the process of changing the memorandum we are going to change the place of our register office from the previous state to this state, that we have an approval order from the central government. That type of sheet or order sheet have to be submitted by the company to the both the previous register office and the new registered office. Okay, registrar. So the register of the state where the registered office is being shifted to shall issue a fresh certificate of incorporation indicating the alteration. So after receiving that the order of the central government, then the registrar of the new places have to issue the certificate of incorporation to the company based on the alteration of its memorandum. The company has changed its place of business from one state to another state like that. Next, change in the object of the company. A company which has raised money from public through prospectus and still has any unutilized amount of the money so raised shall not change its objects for which it raised and the money through prospectus unless a special resolution through postal ballot is passed by the company. For example, when the starting of the company in the need of in the point of requirement of capital, company shall raise the money from the public, so that we are starting a new company and our objective is doing this business. For doing this business we need some money. On the basis of we need some investment from the public, we have this amount of the shares, so those people who are interested can invest the money in our company, like that they will raise the money. So after getting all the amount and some unutilized amount will be there. So for that unutilized amount should be used for the same purpose, or the unutilized amount, when they have the unutilized amount, the company is not subjected to change its memorandum of association without the consent of the previous investors. What they are saying is, so which has raised money from public through prospectus and still have any unutilized amount of money so raised shall not change its objects for which raised. So on which basis they raised money, so those objects will be still remain until the raised money completed. If the raised money is still there means they should not change the objects. So if they want to change means there is some procedure. The procedure is through the money. What they saying is, shall not change its objective for which it raised the money through prospectus unless a special resolution through postal ballot is passed by the company. So if they want to change the objects means they have to pass a special resolution through postal ballot. And they are also saying the details in respect of such resolution shall also be published in the newspapers, one in English and one in vernacular language, means local language. So whenever the company is planning to change the objectives, they have to raise a special resolution, and the special resolution should be published in the local newspapers. One is in English language and another is the vernacular language, that is the local language, which is in circulation at the place where the registered office of the company is situated, and shall also be placed on the website of the company if any indicating therein the justification of such change. The dissenting shareholders shall be given an opportunity to exit by the promoters, and the shareholders having the control in accordance with the regulations to be specified by the Securities and Exchange Board. So some people are there. We are invested the money for these objectives only. If you have the money left means you can use only for those objectives. If you have any plan to change the objectives means we are not interested on that. So you please give the money what we invested back. So those are the shareholders who are not interested in the company's new objectives or new plan, they can left from the company plan, and the company should suppose to give their amount back and remove from the shareholding place of the company. Next, the registrar shall register any alteration of the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of their special resolution. So what the registrar should do when the company change its objectives of the memorandum means then the registrar has to issue a through special resolution the company, then the registrar should alter its memorandum with respect to the object of the company within 30 days. So the registrar has to change it within 30 days. So no alteration made under this section shall have any effect until it has been registered in accordance with the provisions of this section. If anyone plans to change the objectives of the company, it should be the objective should be changed as per the provisions given in this chapter. If not changed as per the provisions given in this chapter means the change does not have any value. Next, only member have a right to participate in the divisible profits of the company. Okay. Any alteration of the memorandum in case of a company limited by guarantee not giving a share capital, intention to give any person a right to participate in the divisible profits of the company, otherwise than as a member shall be void. Okay. Rectification of name of memorandum. Central government to issue direction. According to section 16 of Companies Act 2013, the central government is empowered to give direction to the company to rectify its name, where the name is identical with or too nearly resembles the name by which a company in existence had been previously registered, or the name is identical with or too nearly resembling to a registered trademark within a period of 3 months from the issue of such a direction by passing an ordinary resolution. A company have kept a name, that name is identical to some other company, or a company kept a name that name is very similar to a company already recently registered, then the central government has the power to give the directions to that particular company to change its name. Notice of change to the register, where a company changes its name or obtains the new name, it shall be within a period of 15 days from the date of such change give a notice of the change to the register along with the order of the central government, who shall carry out necessary changes in certificate of incorporation memorandum. So whenever the company is changed its name on the direction of the central government, then it should be given to the registrar and within a period of 15 days. Okay. Where a company changes its name or obtains a new name, it shall within a period of 15 days from the date of such change give the notice of the change to the register. Within 15 days from the change of its name shall give the notice to the register along with the order of the central government, because the register will alter its memorandum and also includes in the certificate of incorporation. Articles of association. Definition of articles of association. The articles of association are the bylaws of the company according to which the director and other officers are required to perform their functions as regards the management of the company. So earlier we discussed about the memorandum of association. Memorandum of association describes about the conditions and the objectives by which the company is formed. What is the share capital? What is the name? What is its registered office location? Who is the registrar? So what is the certificate of incorporation? All these details are included in the memorandum of association. Now articles of association contains the functioning of the company, who should do, what are the duties of these particular directors, what are the duties of other officers, what are the duties of managers. So all these details will be included in the articles of association. Section 5 of the Companies Act 2013 seeks to provide the contents and models of the articles of association as follows. Regulations for management. So regulations for management. The articles of a company shall contain the regulations of the management of the company. Articles of association contains the what are the duties of the management. Inclusion of matters. What are the matters included? The articles are shall also contain such matters as are prescribed under the rules. However, a company may also include such additional matters in its articles as may be considered necessary for its management. If a company feels it necessary for the management of the company, then the company can include any rules that it is required by them in the articles of association. Contains provisions for entrenchment. So the articles may contain provisions for entrenchment to protect something to the effect of that the specified provisions of the articles may be altered only if the conditions or procedures as they are more restrictive than those are applicable. So in the case of special resolution or may need of complied with. So in order to protect the company rules and regulations, company's objectives, company's provisions, articles of association can include other rules also. Manner of inclusion of the entrenchment provision. The provision for the entrenchment shall only be made either on the formation of the company or by an amendment in the articles agreed to by all the members of the company in the case of a private company and by a special resolution in case of a public company. So entrenchment provisions means to protect. So in order to protect the company, the articles of association rules shall be included in it at the time of beginning of the company. Or if you want to create, if you want to include new rules, means you have to do an amendment by an amendment in the articles of association, and that amendment should be agreed by all the members of the company. If in case of it is a private company, so in case of a public company, if you want to include any entrenchment rules, means you have to pass a solution. What is that? Resolution. So in case of a public company, you have to pass a special resolution. In case of a private company, you have to make an amendment which is accepted by every member of the company. Notice to the register of the entrenchment provision, where the articles contains provisions for the entrenchment, whether made on the formation or by the amendment, the company shall give notice to the register of such provisions. So in such form and manner as may be prescribed. Whenever a company makes in the change in articles of association relating to the entrenchment, then it have to give the notice to the register relating to this entrenchment provision. Model articles. A company may adopt all or any of the regulations contained in the model articles applicable to such company. Company registered after the commencement of this act. In the case of any company which is registered after the commencement of this act, insofar as the registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations shall so far as applicable by the regulations of the company in the same manner and to the extent as if they were contained in the duly registered articles of the company. Next section, not apply on company registered under the any previous company law. Nothing in this section shall apply to the articles of the company registered under any previous company law unless amended under this act. If any company is formed, if any articles of association is formed based on the previous company law, that is the Companies Act 1956, the companies those these rules are not applicable to that. But if any company formed under previous Companies Act 1956 and its rules are amended to 2013 means, then though for those companies these rules will be applicable. Alteration of articles means change in articles. Section 14 of the Companies Act 2013 vests the companies with the power to alter or add to its articles. The law with respect to the alteration of articles is as follows. Earlier we studied the alteration of memorandum. It will be the alteration of articles is also similar to it. Alteration by special resolution. You have to pass the special resolution for altering the articles. Okay, subject to the provisions of this act and the conditions contained in its memorandum, if any company may be by a special resolution can alter its articles. Alteration includes the conversion of companies. So alteration of articles include the alteration having the effect of the conversion of a private company into a public company into a private company. So if you convert a public into private or private into public, this is also included in the alteration of articles. Even where a company being a private company alters its articles in such manner that they no longer include the restrictions and limitations which are required to be included in the articles of private company, and this act when such company shall as from the date of such alteration cease to be a private company. So however any such company having the effect of conversion of a public company into a private company, then such conversion shall not take effect except with the approval of the central government on an application. Next, every alteration of the articles and a copy of the order of the central government approving the alteration shall be filed with the registrar together with the printed copy of the article address within a period of 15 days in such manner as may be prescribed. Who shall register the same? Earlier we studied about the alteration of memorandum. When there is alteration, it should file the change relating to this alteration matter to the register within 50 days along with the approval of the central government. The same is also mentioned here. Any alteration of the articles registered as above shall subject to the provisions of this act and be valid as if it were originally contained in the articles.
Next, every alteration made in articles of a company shall be noted in every copy of the articles, as the case may be. If a company makes any default in complying with the stated provisions, the company and every officer who is in default shall be liable for a penalty 1,000 for every copy of articles issued without such alteration. Section 15. So, if a company alterates articles, it has to mention it's a matter of alteration in every copy of the that related to the company. If any person not follows these provisions, he is subjected to a fine of rupees 1,000 every day until the default continues. Copies of memorandum, articles, etc. to be given to the members. So, copies of memorandum and articles of association, every agreement and every resolution referred in section 170 shall, on being so requested by a member, be sent within 7 days of the request on the payment of fees. So, once the member pays the fees, means whatever he requests, he have to, the company shall subject to give all the copies to him. So the memorandum, the articles, and every agreement and every resolution referred in section 117. So all these details, the memorandum, the articles, and every agreement referred under section 117 shall be given to the member on payment of certain fees. In case of default, the company and every officer who is in default shall be liable to each default to a penalty of the 1,000 rupees for each day during which such default continues, or 1 lakh rupees, whichever is less. Privacy in management of companies. Doctrine of constructive office. In consequences of the registration of the memorandum and articles of association of the company with the register of companies, a person dealing with the company is deemed to have constructive notice of their contents. So this is because these documents are constructed as public document under section 399 of the Companies Act 2013. Accordingly, if a person deals with a company in a manner incompatible with the provisions of the aforesaid documents, or enters into transaction which is ultra-wise to those documents, he must do so at his peril. So, where the articles provide that a bill of exchange must be signed by two directors, if the bill is actually signed by one director only, the holder thereof cannot claim payment thereon. However, the doctrine of the constructive notice is not a positive one but a negative one, like that of the estoppel, of which it forms parts. It operates only against the person who has been dealing with the company, but not against the company itself. Person in charge of the management cannot be prevented from wrongdoing on the pretext that he did not know that the constitution of the company rendered a particular act or a particular delegation of the authority ultraverse. Thus, the doctrine is a cloud for the strangers. The doctrine of the indoor management has been recognized in the case of Royal British Bank versus target. While an advisory person dealing with a company is bound to assume that the requisite compliance or delegation of the powers to the person dealing on behalf of the company has been made, he had not proved beyond what is obtainable and evident from the actions. Doctrine of indoor management. This is what about doctrine of uh, constructive notice. So now going to doctrine of indoor management. So the aforesaid doctrine of constructive notice do not assume that the outsiders are deemed to have notice of the internal affairs of the company. For instance, if an act is authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. For example, the directors of the Royal British Bank Limited gave a bond to the Thorcott. The articles empower the directors to issue such bonds under the authority of a proper resolution. In fact, no such resolution was passed, notwithstanding that it was held that T could sue on the bonds on the ground that he was entitled to assume that the resolution had been duly passed. The Royal British Bank versus Torcott. This is the doctrine of indoor management, which is the only limitation to the doctrine of constructive notice discussed above. Exceptions to doctrine of indoor management. The aforementioned rule of doctrine indoor management is important to person dealing with a company through its directors or other person. So they are entitled to assume that the acts of the directors or other officers of the company are validly performed if they are within the scope of their apparent authority, so long as an act is valid under these articles. If done in a particular manner on outsider dealing with the company is entitled to assume that it has been done in the manner required. The above mentioned doctrine of indoor management has limitations of its own. The law will assume that those information which an outsider has a reasonable access to and should have been with minimal efforts before dealing cannot be the basis of indoor management case in his favor. Conversion of companies already registered. According to Section 18 of the Companies Act 2013, a company may convert itself in some other class of company by altering its memorandum and articles of association. So section 18 of the Companies Act 2013, what is it saying means a company convert into some other class of company by changing its articles and memorandum of association. Following is the law with respect to the conversion of the companies already registered. So it should follow the following laws and regulations. They are by alteration of memorandum of articles. A company of any class registered under this act may convert itself as a company of other class under this act by alteration of memorandum and articles of the company in accordance with the provisions of this chapter. By altering it articles and memorandum of association, it can simply change the class of the company from one to another. Next one, file an application to the registrar. Wherever such conversion of companies is required to be done, the company shall file an application to the registrar, who shall, after satisfying himself that the provisions of applicable for the registration of companies have been complied with, close the former registration of the company. So the second method is file a application to the registrar. If he satisfied, he also change the class of the company from one to another. Issue of certificate of incorporation. After registered the required documents, issue a certificate of incorporation in the same manner as in its first registration. After the registry is satisfied, he will issue again a new certificate of incorporation. No effect on the debts, liabilities, etc. incurred before conversion. The registration of the company under this section shall not affect any debts, liabilities, obligations, or contracts incurred or entered into by or on behalf of the company before conversion, and such debts, liabilities, obligations, and contracts may be enforced in the manner as if such registration has not been done. Simply what they are saying is a company is registered at with one class in the in one nature of class, like limited liability nature or unlimited liability nature. Okay, like limited by guarantee or unlimited by guarantee, like that. That is the class in which it is registered at the earlier days. After some period is completed, it changed its thought and it decided to change its class into another nature. Then what it has to do, the procedure under section 18 of the Companies Act 2013 is, first it has to alter its memorandum of association. After altering the memorandum of association, it has to file the application to the registrar. If the registrar is satisfied, he will write the register, he will write the same in the register and issue a new certificate of incorporation. After issuing the new certificate of incorporation, whatever the liabilities and debts that the company is carrying in its previous nature, the same will be continued with the new nature also. Okay. Formation of not-for-profit making companies. So all the companies and businesses today, we can see everything is formed for the purpose of making profit. But how to start an not-for-profit making companies? For various reasons and objectives, people form companies not for profit. The surplus generated in the company, if any, is used for the fulfillment of the objectives of the company, and no profit is distributed to the shareholders. If the company makes some profit out of its business, and the profit is not shared or not distributed among the shareholders, but it is used for the objectives to fulfill the objectives of the company. So a not-for-profit organization, also known as non-business entity or a social enterprise. The other name of not-for-profit making company is non-business or what is it? Non-business entity or social enterprise. In economic terms, a not-for-profit organization uses its surplus revenue to further achieve its purpose or mission, rather than distributing its surplus income to the organization shareholders as a profit or dividends. So whatever they are saying, this company will also form in the same way, but whatever the turnover it make or whatever the profit it make, it is not distributed in between the shareholders, but the amount of profit is again used for achieving its objectives in a decent good way. Such a company has in its object the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any other such objects. These are the objects of not-for-profit making companies, like what they promote: commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or intends to apply its profits, if any, or other income in promoting its objects. The profit of the company is used for promoting its objects itself. Prohibit the payment of any dividend to its members. So the share of profit is not distributed to any shareholders. The central government may, by license on such conditions as it deems fit, allow the association of persons to be registered as a limited company under this section. So without the addition to its name of the word limited, or as the case may be, the words private limited, and thereupon the registrar shall, on application in the prescribed form, register such association of persons as a company under section 8 of the act with the following features. So when a central government sees the objectives of the company and it is satisfied that the company is formed for the benefit of the society, then the central government can make that company is into an association of persons, and the central government can give its new name, like remove the name in its name private limited. Private only can give the name as a limited. It can be treated as a public limited, and the registrar after receiving the approval from the central government can register the same company under the section 8 companies with the features like the company shall enjoy all the privileges and be subject to all the obligations of the limited companies. So whatever the benefits that limited companies receive shall also will be get by this company. A firm may be a member of the company registered under this section. A company shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. When the company change its nature from private limited to limited and it is registered under section 8, then it is not subjected to change the memorandum. So unless it take the approval of the central government, a company may convert itself into a company of any other kind only after complying with such conditions as may be prescribed. It can change into any other company, but it has to stick on to the conditions, follow the condition. Whether the central government is convicted that a limited company registered under this act or under any other previous company law has been formed with any of the objectives specified in clause A of subsection 1 and with the restrictions and prohibitions as mentioned respectively in clause B and C of subsection. So it may by license allow the company to be registered under this section subject to such conditions and to change its name by omitting the word limited or as the case may be the words private limited from its name, and thereupon the registrar shall so on application in the prescribed form register such company. So whatever it is repeated the same points what we discussed earlier. The central government may by order revoke such license on being convicted the affairs of the company are conducted fraudulently or in a manner violative of the objects of the company or prejudicial to the public interest directly to the company to convert its status and change its name to add the word limited or the words private limited as the case may be. If the central government feels that the company after changing into this nature has doing some mistake acts or doing some acts that are which harms the public, then the company can take its words back and change the company into its normal position. So where a license is revoked under subsection 6, the central government may by order if it is satisfied that it is essential in the public interest direct that the company be wound up under this act or amalgamated with another company registered under this section. If the central government after taking its words back and it feels that it is harmful to the public can direct the company to wound up means remove the company or it should not have its individual nature it should combine with some other company. So the central government have the powers to pass them. So next order. Amalgamated. The order provide for such amalgamation to form a single company with such a constitution, properties, powers, rights, interests, authorities, and privileges, and with such liabilities, duties, obligations as may be specified in order. If on the winding up or dissolution of a company registered under this section, so there remains after the satisfaction of its debts and liabilities any asset, they may be transferred to another company registered under this section and having similar objects, subject to such conditions as the tribunal may impose, as may be sold on the proceeds thereof credited to the rehabilitation and insolvency fund formed under section 269 of the Companies Act. If any company is formed under this section and it following its rules and regulations, and in the middle it done some fraudulent activities, because of that activities the central government taken its power back and dissolved the company. After dissolving the company, after refund, after giving all the settling all the assets and liabilities, if any fund amount is left, then that amount will be distributed as some particular fund which are working under this section, like Section 8 companies fund. Okay, so mainly they were saying that all the amount will be credited into the rehabilitation and insolvency fund formed under Section 269 of the Companies Act. This can come as a bid. Next, a company registered under this section shall amalgamate only with another company registered under this section and having similar objects. Certificate of incorporation under this section shall mention permanent account number. So when the central government directed them to dissolve or amalgamate with another company, means this company should amalgamate with another company which have the similar objectives. If a company makes any default in complying with any of the requirement laid down in this section, the company shall, without prejudice to any other sections under the provisions of this section, be punishable with fine which shall not be less than 10 lakh rupees. It is subjected to pay the fine 10 lakh if it violates the provisions that are given by the central government, but which may extend it to 1 crore, and the 10 lakh from 10 lakh to 1 crore. And the directors and every officer of the company who is default shall be punishable with fine which shall not be less than 25,000, but which may extend to 25 lakhs. And the persons who are connected to this violation activities, they are also punishable with fine 25 5 lakhs 25,000 to 25 lakh rupees. provided that when it is proved that the affairs of the company were conducted fraudulently, every officer in default shall be so liable for action under section 447. If it is proved that all the officers of this company have been involved in this fraudulent activities, then they are all punishable under the provisions of section 447 of the Companies Act 2013. License under section 8 for the existing companies. So how a company can get the license under section 8? So a person's desirous of getting a license under section 8 shall make an application in form INC Incorporation 12. The MOA Memorandum of Association shall be in form INC 13, and declaration by profession shall be in INC 14. So they can make the application in INC 12 and the memorandum of INC in 13, and a declaration INC 14 shall be given in order to get the license under section 18. An estimated income and expenditure statement for next 3 years shall also have to be furnished. So what is the estimated income, what is the estimated expenditure for the coming 3 years also be given in order to get the license of section 8. An existing company can also be converted into non-profit company. Application can be made in corporation 12 with MOA and AA declaration, financial statement and audit report of the previous years. In order to convert from normal companies to section 8 company means they have to follow some procedures, and they have to file all the applications related to them, and they have to file their financial statements, balance sheets, audit reports, everything to the applications. Then they will get the, if everything is satisfied, then they will get the license under section 8. Procedures relating to foreign companies carrying on business in India. So what are the procedures that they should, the foreign business carrying in India should follow? According to section 2 plus 42, foreign company means a company or body corporate incorporated outside India and which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any manner. So section 2 plus 42 of the Companies Act 2013, what it says means a foreign company means its main registered office is outside India, but it carrying its branch business in India. So through some agent or any other person. The Companies Act 2013 provides detailed provisions of compliance by the foreign companies carrying on the business in India. Section 379 provides that the provisions of section 380 to 386, 390 to 393 shall apply to foreign companies with or without exemption. Inspection, inquiry or investigation. The provisions as to inspection, inquiry, or investigation under Chapter 14 of the Act shall apply mutatis mutandis to foreign companies also. Okay. Merger into a company registered under this Act or vice versa. Subject to the provisions of any other law for the time being in force, a foreign company may, with prior approval of the Reserve Bank of India, merge into a company registered under this Act or vice versa, and the terms and conditions of the scheme or merger may provide, among other things, for the payment of consideration to the shareholders of merging companies in cash or in deposit receipts, or partly in cash and partly in deposit receipts, as the case may be, as per the scheme be to be drawn up for the purpose. So after taking the approval from the central government, a foreign company can merge into the Indian companies based on some rules and regulations given by the central government. Explanation: for the purpose of subsection 2, the expression foreign company means any company or body corporate incorporated outside India, whether having a place of business in India or not, winding up as an unregistered company. Next, where a body corporate incorporated outside India, which has been carrying on business in India, ceases to carry on the business in India, it may be wound up as an unregistered company under the part, notwithstanding that the body corporate has been dissolved or otherwise ceased to exist as such under as by virtue of the laws of the country under which it was incorporated. Foreign company shall be deemed to be an Indian company for this purpose, where not less than 50% of the paid up share capital, equity or preference or combination thereof a foreign company is held by one or more citizens of India, or by one or more companies or bodies corporate incorporated in India, or by one or more citizens of India and one or more companies or body corporates incorporated in India, whether singly or in aggregate. Such company shall comply with the provisions of Chapter 22 of the Act and such other provisions of the Act as may be prescribed with regard to the business carried on by its India, as if it were a company incorporated in India. So what they are saying under section 379 of the Companies Act 2013 is, if a Indian citizen or Indian company or any other person who having the power in India holds more than 50% of the share capital of a foreign company, then that the foreign company shall be deemed to be an Indian company, and it has to follow all the rules and regulations what an Indian company used to follow. Registration of the registration with the Register of Companies, section 380 clause 1. Every foreign company shall, within 30 days of the establishment of its place of business in India, deliver to the register for registration. If a foreign company established in India, so after establishment of 30 days, it has to follow the following procedures. So the following procedures with the Register of India. Okay, a foreign company shall within 30 days of establishment of place of business in India deliver the register for registration. So after establishing its place of business within 30 days, deliver to the registrar the following one. What are they? A certified copy of the charter, statutes or memorandum and articles of the company or other instrument constituting or defining the constitution of company, and if the instrument is not in English language, a certified translation or thereof in English language, a certified copy of the charter, statute or memorandum and articles. If it is not in English, it has to convert into English and transfer send it to the register of companies. The full address of the registered or principal office of the company, and a list of the directors and secretary of the company containing such particulars as may be prescribed. The name and address or the names and addresses of one or more persons resident in India authorized to accept on behalf of the company services and processes, and any notices or other documents required to be served on the company. The full address of the office of the company in India and which is deemed to be its principal place of business in India. Particulars of opening and closing place of business in India on earlier occasion or occasions. Okay. Next, declaration that none of the directors of the company or authorized representative in India has ever been convicted or debarred from promotion of companies and management in India and abroad. Any other formation as may be prescribed. Any alteration of the above document shall be informed to the register within 30 days. So, when a foreign company establishes its place of business in India, and that the foreign company is subjected to provide all the documents that are mentioned under Section 380 Clause 1 of the Companies Act 2013. So, balance sheet and profit and loss account 381 Clause 1. Every company shall in every calendar year make out a balance sheet and profit and loss account in such form containing such particulars and including or having annexed or attached thereto such documents as may be prescribed, and deliver a copy of those documents to register unless exempted. So every company should transfer its balance sheet, profit and loss account to register, provided that the central government by notification direct that in case of any foreign company or class of foreign companies, the requirements of clause A shall not apply or shall apply subject to such exceptions or modifications as may be specified in that notification. If central government gives them any waiver, they can then they are no need to transfer the profit and loss account and balance sheet copies to the register. If any such document is mentioned in such subsection 1 is not in English language, there shall be annexed to a certified translation thereof in the English language. So the profit and loss account and balance sheet should be changed into English language and transferred to the register. Every foreign company shall send to the register along with the documents required to be delivered to him under subsection 1, a copy of the list in the prescribed form of all the places of the business established by the company in India as the date with reference to which the balance sheet referred to in subsection 1 is made out. Display of name of foreign company section 382. Every foreign company shall conspicuously exhibit on the outside of every office or place where it carries on the business in India the name of the company and the country in which it is incorporated in letters easily legible in English characters and also in the characters of the language or one of the languages in general use in locality in which the office place is situated. So cause the name of the company and of the country in which the company is incorporated to be stated in a legible English character in all business letters, billheads and letter papers, and in all notices and other official publications of the company. And if the liability of the members of the company is limited, cause notice of the fact to be stated in every such prospectus issued and in all business letters, billheads, letter papers, notices, advertisements, and other official publications of the company in legible English characters to be conspicuously exhibited on the outside of every office or place where it carries on business in India in legible English characters and also in legible characters of language or one of the languages in general use in locality in which the office or place is situated. Service documents. Okay. Section 383. Any process notice or other document required to be served on a foreign company shall be deemed to be sufficiently served if addressed to any person whose name and address have been delivered to the register under Section 380 and left it or sent by post to the address which has been delivered to the register election or by election mode. If any address is given to the register related to the particular foreign company of any individual, then the registrar shall send all the documents, all the notices related to the company to that particular person only. The provisions section 71 shall apply mutatis mutandis to foreign companies. The provisions of section 92 shall subject to such exceptions, modifications, and adaptations as may be So therein by the made under this act apply to a foreign company as they apply to a company incorporated in India. So what are the provisions applicable to a Indian company shall also be applicable to a foreign company. The provisions of section 128 shall apply to a foreign company to the extent of requiring it to keep at its principal place of business in India. The book of account referred in the section. So with respect to monies received and spent, the sales and purchases made and the assets and liabilities in the course of or in relation to its business in India. The provisions of Chapter 6 shall apply mutatis mutandis to charges on properties which are created or acquired by any foreign company. The provisions of Chapter 14 shall apply mutatis mutandis to Indian business of a foreign company as they apply to the companies incorporated in India. What they are saying is whatever the rules and regulations that are applicable to the Indian company shall also be applicable to the foreign company. Conversion of LLPs into private limited companies and vice versa, or conversion of private limited companies into LLPs. Okay, choosing from form of business is voluntarily for the entrepreneur, subject to the restriction of law. The provisions of the Companies Act 2013 read with rules made thereunder provides for the conversion of companies from one type of company to the another type of company. So conversion of one type to another company, another type is completely based on their interests. So further, based on their interests, the Companies Act 2013 is providing so many provisions. So which makes it hassle free for them to convert from one business type to another business type. So the company can convert into the following type of companies. A company registered on one phase can convert into any other phase based on itself. So they are doing the business in a legal way, means it is not objected by the Companies Act or it is not objected by the central government. So in the meanwhile, the Companies Act have to provide them lot of solutions to make their business in their own interests. For that reasons only, the company is providing the facilities to alterate the memorandum, alterate the articles of association, change the company into one name to another. All these facilities are provided by the Companies Act 2013. So the companies can convert into the following type of companies: a conversion of private company into public company, conversion of public company into private company, conversion of one-person company to private company or public company, conversion of private company to one-person company, conversion of Section 8 company into any other kind of company, conversion of LLP into company, conversion from private company into limited liability partnership, conversion from unlisted public company into limited liability partnership. We will discuss only two types of conversions, that is from LLP type company and vice versa. Conversion of LLP into company. Okay. What is the procedure of an LLP, a limited liability partnership company, to transfer into company nature? An LLP can be converted into a private limited company as per the provisions contained in section 366 of the Companies Act 2013 and the companies authorized under two registered rules 2014. When a LLP want to convert into private limited company, it has to follow the rules and regulations given under section 366 of the Companies Act 2013. The steps can be initiated in two ways as enumerated below. Incorporation of new corporate entity. Second one, conversion of existing entity, example LLP or partnership form, into a company. The process of conversion is a step-by-step procedure, which is a technical process, but if handled with the expert knowledge, so maybe time and cost savings as well. So it is a technical process, but if an expert is involved in this conversion process, it will be very easy. So Ministry of Corporate Affairs has passed a notification on 31st May 2016. In such a notification, it allowed a conversion of LLP into a company. So these rules called as the Companies Authorized to Register Amendment Act rules under 2016. However, there are various requirements which need to be satisfied for converting LLP into a private limited company. So when an LLP decides to wants to change into private limited company, it has to satisfy so many rules. So, for instance, an LLP must have at least seven partners. However, as per the Companies Amendment Act 2017, LLP with the two partners can be converted to company. Basically, LLP, in order to a private company, at the beginning of this chapter, I have said that, so in order to form a private company, at least seven members are there. But when it is changing from LLP into private company, means that it can be have only two members is also enough. Approval from all the partners is required. Advertisement in a newspaper is to be done in the local and national newspaper. So whoever the members to the LLP, their approval is needed, and a judgment and the news advertisement should be given regarding this change from LLP to another. A newspaper advertisement should also be given. No objection certificate (NOC) is required from the Register of Companies (ROC) where such LLP is registered, and then all the incorporation process has to be undertaken, which includes the following process to be followed. This is the following process in order to convert an LLP into the private limited company. Approval of name. Holding a meeting of the partners to be decide the name of the company, someone for the purpose of the registering the LLP under section 366 of the Companies Act 2013, to authorize the partners to take all steps necessary and to execute all papers deeds, documents, etc. pursuant to registration of LLP as a company. So one of the major advantages is that the business can be run under the same name as that of the LLP, except that in addition to the name of the LLP, the words limited or private limited has to be added. The name once accepted by the authority will be valid for 60 days. So whenever the first the name has to be changed, when changing the name, the partners should conduct a meeting. In that meeting, they have to take a unique decision, and they can change the name from LLP to any limited or private limited company. Okay, securing DSC and a DIN. So in case all two or seven members, as the case may be, who are future directors of the company after the conversion do not have the digital signature certificates, and the director identification number for all the future directors of the company must be obtained. So the LLP partners are becoming the directors of the company. They must have the digital signature certificates and the director identification numbers. So when where LLP is converting into the private company, if they don't have previous limits, they have to acquire. For obtaining the DIN, an application form must be filed on MCA portal. DIN application is processed and approved by central government via the Office of Regional Director, the Ministry of Corporate Affairs. Filing form number URC1. For the purpose of subsection 2 of section 366 of the Companies Act 2013, the provisions of chapter 2 of the Act relating to the incorporation of company and matters incidental thereto shall be applicable mutatis for such registration, provided that there shall be two or more members for the purpose of registration of a company, and this sub-rule, provided further that a company with less than 7 members shall register as a private company. A company shall attach and provide the required documents and information to the register along with form number URC1 in the following manner, namely, what is that? In case of an application by a limited company, limited liability partnership, or a form or for registration as a company limited by shares, a list showing the names, addresses, and occupations of all persons named therein as partners with the details of the shares held by them respectively, showing separately shared allotted for consideration and cash and for consideration other than cash, along with the source of consideration, and distinguishing in cases where the shared or numbered each share by its number who on a day not being more than 6 clear days so before the day of seeking registration, where partners of the limited liability partnership are formed as the case may be. So a list showing the particulars of the persons proposed as the first directors of the company, along with the director identification number, passport number, if any, with expiry date, residential address, and their interest in other form or body corporate, so along with their consent to act as directors of the company. So in case of a form deed, the partnership bylaws or other instrument constituting or regulating the form, and so in case the deed of the partnership was revised at any time in the past copies, and principal all subsequent deeds including the latest deed, along with the certificate of the registration issued by the registrar of the forms in case of the form is registered, written consent number, no objection certificate from all the security creditors of the applicant. So written consent from the majority of the members, whether the present in the person or by proxy at a general meeting, agreeing for such registration, provided that where shall be two or more members for the purposes of the registration of a company under the sub-rule, provided further that a company with less than 7 members shall register as a company.
Now, B. Conversion of company into LLP. Any existing private company or existing unlisted public company can be converted into LLP by complying with the provisions of Section 58 and Schedule 3 and 4 of the LLP Act. So earlier we studied about the LLP conversion into company. Now we are studying about company into LLP conversion. Okay. So board meeting. Pass resolution for conversion of company into LLP and to authorize any directors to file all the necessary forms with Ministry of Corporate Affairs MCA. First, they have to pass the resolution for conversion of company into LLP. So take the written consent of all the shareholders for the conversion of company into LLP. Those who are the shareholders existing in the company, from them they have to take the written consent that they are interested, that they are okay with the conversion of company format into LLP format. So name availability approval. So file web-based form run LLP with ROC. Board resolution passed by the company approving the conversion into LLP shall be attached with the aforesaid form. Agreement. Limited liability partnership agreement shall have the following issues. Name of LLP, name of partners and designated partners, form of contribution, profit sharing ratio, rights and duties of partners, proposed business, rules of governing the LLP. It is not necessary to have the LLP agreement signed at the time of incorporation, as the details of the same needs to be filed in E-Form 3 within 30 days of the incorporation. But in order to avoid any dispute between the partners as to the terms and conditions of the agreement after the conversion into LLP, it is required to be drafted various documents to authenticate registered office and other statements, etc., are to be filed. Filing of application for conversion. What they have to file? File E-Form 18 with ROC along with the following attachments. E-Form 18 should be filed for the purpose of converting the company into LLP. Statement and also the following should also be filed. Statement of the shareholders. It is the document given by each shareholders giving their consent and statement. So they have to give in a statement that we are okay with the conversion of company format into LLP. Statement of assets and liabilities of the company duly certified as true and correct by the auditor. So an auditor has to give the significant nature that all the assets and that all the assets are true, assets and liabilities of that are held by the company are true and correct. In case of in case all 2 or 7 members, as the case may be, who are future directors of the company after conversion, do not have the digital signature certificate and director identification number, for all the future directors of the company must be obtained. So those who don't have the a digital signature certificate or a digital identification number, though acting for the director's nature, they should get both of them. For obtaining the DIN, an application form must be filed on MCA, Ministry of Corporate Affairs portal. Director identification number application is processed and approved by the central government via the office of the regional director, the Ministry of Corporate Affairs. Filing of form number URC1 for the purposes of subsection 2 of section 366 of the Companies Act 2013, the provisions of chapter 2 of the act are relating to the corporation of the company and matters incidental thereto shall be applicable mutatis mutandis for such registration, provided that there shall be two or more members for the purposes of registration of a company under this sub rule. Provided further that a company with less than 7 members shall register as a private company. So less than 7 members, it should register as a company. A company shall attach the following manner, namely the following should be attached in order to convert into LLP. In case of application by limited liability partnership or a form of registration as a company limited by shares, a list. What is this? Okay. So, okay. A list showing the names, addresses, and occupations of all persons named therein as partners with details of the shares held by them, respectively. What are the shares held? What are their names? What are their addresses? All the details should also be mentioned. Showing separately shares allotted for consideration and cash or for consideration other than cash, along with the source of consideration and distinguishing in cases where the shares are numbered, each share by its number. So, who are on a day not being more than 6 clear days before the day of seeking registrations, where partners of limited liability partnership are formed, as the case may be. A list showing the particulars of persons proposed as the first directors of the company, along with the director's identification number, passport number if any, with the expiry date, residential address, and their interest in the form or body corporate, along with their consent to act as directors of the company. In case of a form deed of partnership, bylaws, or other instruction so constituting or regulating of the form, and in case of the deed of partnership was given at any time in the past, copies of the principal and shall subsequent deeds, including the latest deed, along with certificate of registration issued by the register of the forms in case of the register, written consent or no objection certificate from all the secured creditors of the applicant, written consent from the majority of the members, whether present in the person or by proxy at general meeting, greeting for such registration, provided that there shall be 2 or more members of the purposes of registration of a company under the sub rule, provided further that a company with less than 7 members shall register as a private company. So yeah, up to here, the first topic is completed. If you like this explanation and if you feel that this is very useful video, useful lecture for all of you, please like the video and also share this video for the friends who were studying the CMA final, and subscribe this channel for the next topic I'm going to teach in the next video. The next topic will be the investment and loans. So meet you in the next video. Bye bye. Take care.